Right, there appear to be three different cases that are scheduled to be before the court today. Butler County case numbers 2025 CR 18, 25 CR 183, 23 TR 3540, all involving State of Kansas versus Jamal Dominique Singleton. Cheryl Pierce appearing for the State of Kansas and the Butler County Attorney's Office. If you'll rejoin us with video, Ms. Pierce.
Judge, I'm sorry.
Judge Joseph Favre appears as defense counsel with Mr. Singleton appearing from the Butler County Jail Zoom location. This matter comes before the court at this time for arraignment on the primary charge in case number 25 CR 18. I'll ask Mr. Favre, does your client desire the charging document to be read to him in that case?
He does not, Judge. He would waive a formal reading.
All right. And what pleas are going to be entered today?
So, Judge, we actually are ready to proceed with the plea, but there's a little bit of a hiccup in that Ms. Pierce had sent me the written plea agreement. I have reviewed that with Mr. Singleton orally, but I have not had a chance to visit him in the jail to have it signed. Mr. Singleton is requesting that we proceed with it orally today. It's a fairly simple plea, and that I will work on getting that signed and entered in sometime in the next week when I get out there to see him.
I think that makes practical sense, Mr. Favre. So what announcement is made regarding case resolution regarding one, two, or all three of these cases?
Judge, I think the resolution would encompass all three, although Ms. Norris is on his other case and she appears to have dropped off the meeting. But we do have an. Sorry,
I have
Cheryl.
all three of the files, Jeff.
Okay, great. So on the main case, 25 CR 18, State has amended the information on count 1 to a level 6 violation of Offender Registration Act. Mr. Singleton is going to be pleading guilty to that. State will dismiss remaining counts in that information. At time of sentencing, the joint recommendation will be the aggravated number in the column, the box he falls in, which we think will be A box, A6. So we're anticipating a 46-month aggravated number. Mr. Singleton will agree to serve that time in DOC, not file a departure in this matter. That's the sum of the agreement basically in 25 CR 18. In 20, in the other case with Ms. Norris, 25, let's see, let me pull that file up here. Sorry, I had the wrong one.
183.
Okay, yes, 25 CR 183. State will amend to a misdemeanor criminal damage to property. Ms. Norris would like 60 days on that case to run concurrent with other cases. And Mr. Singleton will agree to restitution, which I reviewed that restitution with him. It's the amount of $1,500, I think $48. I have the receipt here. And he will agree to full restitution in that amount, as well as after that, I think the 60 days, I think it's just cost open and owing and closed because he's going to be doing time in the other case. And then the traffic case would be dismissed pursuant to the plea agreement.
All right, Ms. Pierce, has Mr. Favre announced consistently with your office's view as to how these cases would be handled?
Yes, Your Honor.
All right. Importantly, Mr. Singleton, you've been present when your attorneys made an announcement on your behalf as to how all of these three cases would be resolved. Are you in agreement with what has been announced?
Yes, sir.
All right. Well, felony is involved here, and there's going to be a number of questions I'm going to ask you about that. But I think we'll just go ahead and start with the criminal damage to property case. It's court's understanding that you'd be pleading to misdemeanor criminal damage to property. That would be a Class B misdemeanor, Mr. Favre?
That is correct. I said A, but it's a Class B.
All right. Do you agree, Ms. Pierce?
Yes.
All right. You understand, Mr. Singleton, that Class B misdemeanors are punishable by up to a $1,000 fine and up to 6 months in the county jail?
Yes, sir.
All right. According to the state's charging document, this criminal damage to property took place April 15th of 2025. Is that when it happened?
Yes, sir. I believe so.
All right. And they allege that you damaged a door at the Butler County Jail. Did you do that?
Yes, sir.
How did you damage it?
I was kicking the door and foot hit the window and it shattered.
All right. So do you now freely, knowingly, and voluntarily enter a plea of guilty and accept conviction for a misdemeanor criminal damage to property, a Class B misdemeanor?
I do.
The court will accept the defendant's plea to that misdemeanor, finding it's a free voluntary act on his part. There's a factual basis to support it. He's been made aware of the possible penalties. We will defer sentencing until later. All right, turning to the felony, I've got a series of questions I need to ask you regarding that, Mr. Singleton. If there's anything you don't understand, I'll give you the opportunity to confer privately again with your attorney, Joe Favre. Just let the court know if you need that time to get further legal advice, okay?
Yes, sir.
State your full legal name for the record.
Jamal Dominique Singleton,
How old are you right now?
31 years old,
What's the highest level of education that you've attained?
12.
Now, do you believe you're going to have difficulty understanding any of the legal concepts we're going to be discussing in court here today?
No, I do not.
Okay. Have you ever been adjudged to be mentally ill?
No,
Are you currently under the influence of alcohol or any drug?
no, sir.
Are you currently taking any type of prescription medication?
Yes.
Is it mental health related, Mr. Singleton?
No, I just recently stopped that, but I'm on a blood pressure pill and albuterol inhaler.
Okay. As you sit today, do you believe your mind is clear and that you have a full understanding of what's going on in court?
Yes, I do.
Did you receive a copy of the original charging document in this 25 CR 18 case?
I believe I did.
It is your, of course, your offender registration case.
Yes, I did.
All right. Do you understand the nature of the charge of offender registration violation?
Yes, I do.
Right. You understand that when you enter a plea of guilty, you are admitting the act of offender registration that's been charged by the state?
Yes, sir.
You further understand that by entering a plea of guilty, you give up any legal defenses that you might have had to that charge?
Yes, sir.
Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses at your trial with the assistance of your lawyer, and that you could present evidence on your own behalf and subpoena your own witnesses to court?
Yes, sir.
You also understand that at such a trial, you personally would have a privilege against self-incrimination, which means that you could testify under oath in your case at your choice, but no one could force you or compel you to testify against yourself if you didn't want to. You understand that, Mr. Singleton?
Yes, I do.
You understand that when you enter a plea of guilty, you give up these valuable trial rights that the court has described?
Yes, sir.
Are you also aware that you have a right to a trial by jury? And before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt.
Yes, sir.
You understand that when you enter a plea of guilty, you give up your right to a trial by jury and that requirement that you be found guilty beyond a reasonable doubt.
I do.
All right. You understand that you have a right to appeal a guilty verdict if you have a trial.
Yes, sir.
You further understand that you may appeal your sentence after entering a plea of guilty, but generally you may not appeal your judgment of conviction after entering such a plea.
Yes, sir.
Now, are you aware of the sentence that could be imposed as a result of this guilty plea that you are attempting to make?
Yes, sir.
Right. I have a copy of the sentencing range for non-drug offenses under the Kansas Sentencing Guidelines Act before me. In the most favorable criminal history category of I, you could receive as little as a 17-month sentence. In the worst criminal history category of A, you could receive up to a 46-month sentence. So the sentencing range is 17 to 46 months in prison, depending on your criminal history. Mr. Singleton, as you sit today, we do not know with certainty what your criminal history is. You better than anyone else here should really know what your own criminal record looks like, but that will be researched by the Court Services Department based on the outcome of their research as of the date of your sentencing. That determines where you fall along the level 6 line, and then you'll be sentenced accordingly. Do you understand that?
Yes, sir.
And Mr. Singleton, do you understand that if you have any felonies on your record at time of sentencing, you would be presumptive prison here?
Yes, sir.
All right. You also understand that you could receive up to a $100,000 fine for this offense?
Yes, sir.
In addition to any fine, are you aware that you could be assessed and be required to pay court costs, certain fees, including reimbursement of legal fees and expenses, and restitution to victims, if any are owed, as part of
Yes.
your sentencing orders?
Yes, sir.
Did you in fact agree to, backing up on you for just a moment here, Mr. Singleton, do you in fact agree to the over $1,500 restitution number in the criminal damage to property case that we discussed earlier?
Yes, sir.
Okay. You also realize, Mr. Singleton, that as a direct consequence of this plea, you will be sentenced to an extended period of reporting probation, reporting parole, or post-release supervision, which is your state parole time that you do after you get out of prison, as deemed appropriate by the court at time of sentencing.
I understand.
All right. You also understand that these post-release supervision periods generally start at 12 months in duration, but can run up to 60 months under some circumstances.
Yes, sir.
Now, you understand that the Kansas Sentencing Guidelines Act contains many special rules. Do you understand that if any special sentencing rules apply to you and your situation, it could affect your eligibility for probation or otherwise affect your sentence? You understand that?
I understand.
Now, have you had an ample opportunity to discuss fully legal matters like that with your attorney, Mr. Favre, before proceeding here today?
Yes, I have.
All right. Are you satisfied with the services and advice given to you by your lawyer?
Yes, sir.
Now, this guilty plea that you're attempting to make, has it been based upon any threat or promises as to what this court will do in regards to your sentence or any other type of threat or promise?
No, sir.
Singleton, do you understand that there have been any plea deals between your counsel and the county attorney's office that the court is not bound by any agreements made? The court may and shall consider them as recommendations, but is not bound by them. Do you understand that?
I understand.
All right. Mr. Singleton also wanted to address something that your attorney had announced earlier, and that is regarding your waiver of a departure motion. Did he discuss that with you?
Yes, he has.
Departure is an exception to the general rule. For example, if the general rule was for your case that you're going to be sent to prison, a departure motion would seek probation nevertheless. So it would be seeking an exception to the general rule. You've agreed not to seek that exception. Is that correct?
Yes, sir.
Okay. Let me ask you formally at this time, Mr. Singleton, how do you plead to the charge of offender registration violation, a level 6 felony?
Guilty.
All right. Let's talk about that one for a moment. I didn't know what count you were pleading to when Mr. Favre announced. Would he be pleading to count 1 as charged?
No,
It's an amended count 1, Your Honor.
It's
Okay.
an amended count 1, and then all the other counts are dismissed, Judge.
All right.
For your clarification, count 1 presently is a level 5 with a prior. The amended information would be a level 6. It would not be, it would not include a prior.
All right. Similarly to how it was charged in the original information. Would you agree, Ms. Pierce?
Yes.
All right. According to the state's charging document, as amended, sometime back in July of 2024, you failed to report as a registered offender. Do you recognize that, Mr. Singleton?
I do.
All right. Why do you have to register as an offender?
I have a juvenile 6 case.
Okay.
Mm,
And you were supposed to have registered in July of 2024, and you failed to do so. Is that what you're telling me?
Yes, sir.
Okay. And you were to report in Butler County, and you failed to report in Butler County, correct?
Yes, sir.
All right. And at that time, you had to report in Butler County because you were residing or was located in Butler County at that time. Is that correct, Mr. Singleton?
Yes, sir.
All right. So do you now freely, knowingly, and voluntarily enter a plea of guilty and accept conviction for level 6 offender registration as alleged by the state in amended count 1?
Yes, sir.
All right. Mr. Favre, do you know of any legal reason why the court shouldn't accept your client's plea?
I do not.
Ms. Pierce, are you aware of any such legal reason?
No,
Mr. Singleton, are you aware of a legal reason or any other good reason why the court shouldn't proceed further with this plea at this time?
No, I do not.
Very well. The court at this time will accept Mr. Singleton's plea of guilty, finds that that plea is made voluntarily. He has an understanding of the nature of his charge and the consequences of his plea, and a factual basis for the plea does exist. The court will accept the defendant's plea of guilty and finds him convicted in amended count 1 of level 6 felony offender registration violation. The court dismisses all other counts of the information pursuant to plea agreement. The court dismisses traffic case number 23 TR 3540 as part of the plea agreement in the case. Court orders a pre-sentence report be completed to accurately determine Mr. Singleton's criminal history, and the court will set an appropriate date for sentencing. We generally have to allow about 2 months for that, Mr. Singleton, for that pre-sentence report to be compiled. So I'm going to set your sentencing date sometime around middle August.
Thursdays are generally pretty busy, but it looks like I have some time late morning for a Zoom.
All right, so if the court were to set the Singleton sentencing for 11 o'clock, could you commit to that, Mr. Favre?
Yes, Judge.
All right. Court will set sentencing for Mr. Singleton, 11 o'clock a.m., Thursday, August 21, 2025 by Zoom. Defendant obviously must fully participate by audio and visual means at that time. Thursday, August 21, 11 o'clock a.m. If you're asked to do any type of risk needs assessment of any kind, you'll need to comply with that, Mr. Singleton.
Yes,
And
sir.
the court service office would approach you with that. August 21, 11 o'clock. Anything else at this time that we need to address from the state's perspective, Ms. Pierce?
no, Judge.
Mr. Favre, anything further from the defense at this time?
No, Your Honor.
You have any questions or concerns about what we've done here this morning, Mr. Singleton?
No, sir.
Mr. Singleton, you've handled yourself quite appropriately. Again, if you'll please cooperate with any pre-sentence investigation process that you're asked to cooperate with, and we'll see you for sentencing by Zoom Thursday, August 21, 11 o'clock a.m. I'll just state for the record that the court will be announcing its misdemeanor sentence at that time as well.
Thank you.
There's nothing further. The Singleton matters will currently be in recess, and this meeting may be ended.
Thanks for watching. Make sure to hit that like and subscribe button for more crazy court hearings like this one.